Good afternoon, everyone. Welcome to the Judicial Proceedings Committee. Today is Wednesday, January 24th, 2024. Today, we are joined by an esteemed group of individuals from the Office of Administrative Hearings. We've got Chief Judge Chung Pak. We've got Latanya Dargan, who is the Executive Administrative Law Judge and Director of Quality Assurance. And then we've got John Lendig, who is the Executive Administrative Judge and Director of Operations. We've also got a number of folks in attendance to answer questions, but I don't know if they have a formal speaking role up front. We have Emily Danaker, who's the Executive Administrative Law Judge. We have Dinara Harvel, who is the Director of Finance and Administration. Tarek Ibrahim, who is in the back there, Director of Information Technology. And Miss Hampton, so there you are. My girl, you are Executive Administrative Law Judge and Deputy Director of Operations. All right. So the reason I thought it was important to have this briefing before we have our hearings is that the Office of Administrative Hearings, established in 1990, hears more cases than any other branch of any other part of the judiciary. It's administrative hearings. Obviously, they get it. There are cases from every agency. You heard well over 30,000 cases last year. All attorneys go through an initial training of about 10 months to a year of initial training. Yes, of training before they get onboarded. So the training is intense. The subject matter is vast. And on occasion, this committee gives them jurisdiction over more material. So I think most recently was probably a product of police reform. But before that was a thing, we had the Handgun Permit Review Board and so on. And so this committee tends to shovel off jurisdiction and responsibility to these folks. But this is the most, I think, highly technical, highly competent group of administrative judges that I've ever seen. I had an opportunity to go visit them, and just the breadth and depth of knowledge and the wide array of subject matter. It's so important, but not very many people know about its function and form. It's only, it's only been around since 1990, but still, it plays a critical role in how decisions are made. Everything from, like I said, police disciplinary matters to if you have a health benefit, dispute. So all of those things funnel through this entity. And so we're just delighted to have you all in attendance and give us some more background and information. So Mr. Chief Judge, if you'd like to take the floor, we'll start off with you and we'll move on.
I am Chief Administrative Law Judge of the Maryland Office of Administrative Hearings. I've been there for last 3 years. And I want to thank Chairman Smith and the members of Judicial Proceedings Committee for giving us an opportunity to inform you about Maryland Office of Administrative Hearings. We meet today is my management team. Chairman Smith already introduced them, so I don't have to introduce them again. But they are here to answer your questions during or after the presentation. I'm going to now turn it over to our Director of Quality Assurance, Latanya Dargan, who's been with the OAH for at least 15, 20 years. So with that, Latanya.
Thank you, Chief Judge Pak. Good afternoon, Senators. Thank you so much for giving us the opportunity to be here today to talk to you about the Office of Administrative Hearings. I'm going to give you a little information about our background and history before I talk about what we currently do. So prior to January 1, 1990, if a citizen or entity of the state of Maryland disputed the proposed action of an administrative agency of the state, they could request a hearing to contest that proposed action. The wrinkle was that the decision maker was often a hearing officer employed by that agency. So in the late 1980s, a task force was formed to address widespread concerns about the fairness of that process, as well as the effectiveness of the process and the possible excessive costs of each state agency conducting its own hearings. Prior to 1990, various state agencies employed approximately 85 full-time hearing officers and 5 contractual hearing officers or examiners to conduct administrative hearings. The Maryland Office of Administrative Hearings was created as a centralized agency to conduct administrative proceedings on January 1, 1990. I want to talk a little bit about the office's mission statement. So it is to provide prompt, accessible, and efficient due process for any person or business affected by the action or proposed action of state and government agencies. This mission statement informs almost every action taken by every single employee of the Office of Administrative Hearings as we conduct the state's business. Our value statement expands on and deepens the general guiding principle of our mission statement. And our value statement is that we are committed to upholding the highest standards of justice, fairness, and impartiality. Our goal is to provide a transparent and efficient platform for resolving administrative disputes and ensuring that all parties are heard and treated with respect. We strive to foster a culture of integrity and excellence, guided by the principles of due process and the rule of law. From that mission and value statement flow our core values. And all of these values flow through how the Office of Administrative Hearings conducts the business of providing that prompt, accessible, and efficient due process. And these are our values: integrity, fairness, access to justice, efficiency, accountability, diversity, and inclusion. Almost every state in the country has an agency that is similar to the Office of Administrative Hearings. Some of those agencies specialize in a particular case type. That's the only type of case that they hear. But 28 of the states that have the equivalent of the Maryland Office of Administrative Hearings are what we call central panels, meaning that they have jurisdiction to hear a broad variety of case types across and delegated to them by various state agencies. The Maryland OAH serves as a model among those central panels because of the sheer breadth and scope of our jurisdiction, as Senator Smith alluded to earlier. As I indicated, as Chief Pock indicated, I'm the Director of the Quality Assurance Division. QA is responsible for providing both the initial and continuing training and legal education of the administrative law judges. We're empowered to do that under State Government Article Title IX, Section 1604. That is one of the sections of the OAH enabling statute. QA is also responsible for providing resources and other guidance to the ALJs to ensure that all of the work of the OAH is of the highest caliber. In addition to myself and Deputy Director Daniker, the division is comprised of 4 staff attorneys, 1 paralegal, 1 librarian, and a management associate. The QA paralegal serves as the OAH publishing portal coordinator. Since approximately September of 2017, the office has strived to put as many of our final decisions across a number of different case types on our website. So if someone, for example, has a hearing before the OAH and they want to see what the decision might look like, they want to see what type of evidence they need to present, they could go to our website and go to the decision portal and read some decisions in that case type to get an example of what to expect. In conjunction with the operations division, quality assurance periodically reviews OAH hearing notices, our website, other forms and templates to make sure that they are readable and accessible. And where appropriate, we revise to achieve that goal. I want to talk a little bit about both the initial and continuing ALJ training because they're a very important part of what we do at the office. So as Senator Smith noted, initial training is approximately 10 to 12 months. Now, during that period, the newest ALJs are getting exposed to hearings. At the beginning of training, ALJ Daniker and I will hold a training on conducting an effective contested case hearing. So all of the best practices accumulated over the 34 years of the agency of how to effectively run and manage a contested case proceeding. And then just as the new ALJ gets ready to transition into presiding over cases that have a written decision, We also provide training on writing an effective administrative decision. Throughout the initial training, throughout the continuing training of the ALJs, we put an emphasis on using plain language in both oral and written communication. And that helps to ensure that both the hearing process and the final or proposed decision that is issued by the administrative law judge is as accessible to as many people as possible. We have approximately 13 core subject matters. And when I say core subject matters, what I mean is those are the cases where we always have hearings. In fact, from almost the inception of the agency, some of those other administrative agencies have been with us and have been delegating cases to us. And in those core subject matters, new ALJs receive overviews on the statutes, regulations, and case law that govern that subject matter. So they get sort of the broad legal framework for the case type before they start seeing hearings. And then after the overview, new ALJs have the opportunity to observe hearings that are conducted by experienced ALJs. And after observing a number of those hearings, then they have the opportunity to conduct hearings while being observed by experienced ALJs. We find that particular aspect of the training to be extremely effective because it allows for real-time dialogue between the new and experienced ALJ, where the new ALJ is getting feedback and critique that they can then incorporate into what they're doing for later cases on that same docket or for future dockets. In addition to the initial training, we provide continuing legal education to the administrative law judges. Throughout the year, one Friday a month, we've set aside to have training sessions on various topics in administrative law and other relevant substantive areas of the law that impact the work that we do. We do both in-house training, and by that I mean we have ALJs who are subject matter specialists or experts in certain case types will do a whole training to present to their colleagues. And then we also have outside trainers. So professional colleagues from our fellow state agencies come to talk to us about these important developments in the law and different areas of the law. Our division, the Quality Assurance Division, also publishes a weekly newsletter that's designed to keep the ALJs informed of new developments in statutory and regulatory law, new opinions issued from the appellate courts of Maryland on topics of administrative law and other substantive areas of the law. We provide research guidance, writing tips, and we even give people a heads up about notable continuing legal education opportunities that are provided by outside sources. Under the Administrative Procedure Act, there must be a decision rendered in a contested case. State Government Article Title 10, Section 220 governs proposed decisions, and State Government Article Title 10, Section 221 governs final decisions. We have 5 case types where the ALJs issue the decision from the bench, and they are licensure, suspension, and revocation hearings delegated to us by the Motor Vehicle Administration, involuntary admission hearings delegated to us by the Maryland Department of Health, and that's where someone could potentially be involuntarily admitted for inpatient psychiatric care and treatment. Clinical review panel appeal hearings, also delegated to us by the Maryland Department of Health. That's where someone could potentially be involuntarily administered medication, psychiatric medication. We do patient bill of rights hearings. That's another case type delegated to us by the Maryland Department of Health, and that deals with the potential involuntary discharge from a nursing or other long-term care facility. And then we render bench decisions in hearings delegated to us by the Developmental Disabilities Administration, certain hearings. In all other case types, the ALJs of the OAH issue a written decision, either proposed or final. Now I want to talk a little bit about the content of those decisions. So under the APA, proposed decisions must have separate findings of fact, separate conclusions of law, and they must contain an explanation of how someone can avail themselves of the exceptions process to challenge the decision if the party is dissatisfied. A final decision must have separate findings of fact, separate conclusions of law, an order, and an explanation of the appeal or review rights. So these are the components of a written decision that you would get from the OAH. Every written decision is going to have these elements to them. The statement of the case is the procedural history. It's the who, what, when, where, and why of how the case got to the OAH. The issues identify the questions raised by the dispute and that the administrative law judge is expected by the parties to answer. The summary of the evidence details exactly that: the documentary evidence that was admitted and the witnesses who testified. The findings of fact are probably one of the most, if not the most important decisional element because it influences everything else. It forms the foundation of the discussion and the ALJ's analysis of the evidence and application of the law to the facts. The discussion is where you'll find the legal framework, the constellation of statutes and regulations that govern the case type, as well as any case law that might be pertinent or relevant. It will have an analysis of the relationship between the facts and the law. That's where you'll find the ALJ's credibility assessments for witnesses, as well as a discussion of which arguments were persuasive and why, and which arguments might not have been persuasive and why. The conclusions of law constitute the application of the law to the facts. They are supposed to answer the questions posed by the issues. And one of the sort of internal checks to make sure that you've written a complete decision is when you're pulling together your conclusions of law, does each conclusion of law answer a question posed by the issues? The order or proposed order directs the parties what is going to happen next. It will tell the administrative agency or the other party, this is what you have to do now in light of the ultimate conclusions in the case. And then, as I noted, as required under the APA, the review rights or the rights to file exceptions will explain to the parties what to do if they're dissatisfied with the decision. So how do cases get to the Office of Administrative Hearings? These are the different ways: agency delegation, statutory delegation. Every once in a while, an administrative agency will have a case that presents really novel or unusual facts or issues, or it may be something that has a number of moving parts. And agencies will occasionally delegate things to us on a case-by-case basis using a memorandum of understanding. However a case gets delegated to us, whether it's through MOU, statute, agency delegation, under the APA, the Office of Administrative Hearings is required to apply the delegating agency's pre-existing settled policies as if the agency itself is acting as the decision maker. This next slide shows you, just gives you a sense of some of the different administrative agencies and the administrative units within those agencies that delegate hearing authority to the Office of Administrative Hearings. As you can see, it's quite a bit. We do hearings delegated to us by approximately 30 to 35 Maryland state agencies across approximately 200 different programs and in approximately 500 different case types. And these are some of the agencies that delegate hearing authority to us. Administrative law is a lot about statute and regulation. What are the state's formal policy-making processes? And to that end, the Office of Administrative Hearings, as well as many of the other administrative agencies that delegate hearings to us, we have our own procedural regulations, and those agencies have their procedural regulations. And the rules, our rules of procedure and our fellow agencies' rules of procedure are designed to complement and supplement each other. All of our rules of procedure are important, but these 6 on the screen in front of you are the ones that are most commonly referenced and relied on either during the administrative hearing itself or in managing the case and moving it through the entire contested case process, from the request for hearing all the way through to the issuance of the decision. Party representation is particularly interesting because under the office's enabling statute, non-attorneys can represent the interests of a party in a contested case hearing in certain case types that are specifically outlined and accepted in the statute. The powers and duties of the ALJ is what lays out all of the rules that govern how an administrative law judge can manage the proceeding to balance both efficiency against the effective delivery of efficient due process. We have a very heavy motions practice at the Office of Administrative Hearings. A lot of administrative agencies and their representatives are very comfortable with making dispositive motions, discovery motions, and the like. And so Regulation 12 helps guide the ALJs in handling and managing and deciding those motions. The office has, for a long time, even before the COVID-19 pandemic, had the ability to conduct hearings by means of other than in person. We had the ability to do telephonic hearings and video hearings. And so Regulation 20 is the regulation that governs that and that explains what you're looking for when you're doing a remote hearing versus an in-person hearing. And then, of course, evidence is evidence is important in any judicial proceeding. And so Regulation 21 deals with questions of evidence and the burden of proof. And unless anybody has any questions for me, all right, I'm going to turn things over to our Director of Operations, Executive Administrative Law Judge John Leidig.
Should you want to? Senator Sidnor has a question, but can we hold the question till to the very end, and we'll do that, and then we'll go forward.
Thank you, Judge Dargan, and thank you to the members of the committee for this opportunity to provide you with a briefing on the work done by the Office of Administrative Hearings. My name is John Leidig, and I'm the Director of Operations. The role of operations is to ensure that every aspect of the hearing process runs smoothly. So that involves case intake, scheduling, case assignment, noticing, conducting the hearing, and very importantly, issuing a timely decision. Judge Dargan outlined that some of our decisions are bench decisions, but there are many written decisions. On average, an ALJ issues about 50 written decisions every year. And every one of those decisions has a time frame that is 90 days or less. The Operations Division also supervises the administrative law judges, the clerk's office, and support staff. We do have 62 support staff, and that includes 26 clerks. I'm happy to report that we have no backlog of cases at the Office of Administrative Hearings, and part of the reason for that is that we quickly pivoted to remote hearings in 2020 when COVID hit. We do have 55 administrative law judges at present. These are highly qualified individuals, as Senator Smith mentioned. They must have at least 5 years of experience and be members in good standing of the Maryland Bar. They come from a variety of backgrounds. So we have people from private practice, from nonprofits, from the Attorney General's office, the state's attorney, the public defender, and others. And they come from around the state. Our judges are also trained as mediators, and this is very helpful to the resolution of many of the cases that come to us. When a special education case, for example, comes, the participants can choose both mediation and a due process hearing. We're equipped to handle both. The same thing for foreclosures. We conduct mediations for foreclosures. We're also able to conduct settlement conferences or mediations for any case type if the parties request it. To be a certified mediator, all of our ALJs must go through not only a 40-hour initial training, but annual training to make sure that their skills stay current. Senator Smith alluded to our case volume. Case volume did go up from fiscal year 22 to fiscal year 23 by over 10%. And the current fiscal year 24, is on track to match the number from fiscal year 23. So we handle a large number of cases, and as I mentioned, a lot of those require written decisions, sometimes lengthy decisions. OAH in the past has partnered with other state agencies to provide assistance in the form of ALJ assistance or training assistance. This slide just shows a couple of the collaborations with the tax court, the Department of Labor, and the district court. We're especially proud of the training that we provide to our judges. And as you can see, the district court reached out to us about the training. And we particularly appreciate the support that we've received from the governor and from the General Assembly to give us the resources we need to properly train our administrative law judges. Last year, we received a favorable audit from the Office of Legislative Audits, and there were no findings. And we're especially proud of our timeliness rate. It's over 99.7%. We're also happy to report that 46% of the special education mediations that reach us are settled at the mediation table. An even greater number of those cases settle before they go to hearing, but 46 settle when they're there with our judges as mediators. One Friday of every month is dedicated to training the ALJs. This is necessary because we handle so many different case types. It's over 500 different case types when you count all of the agencies and then the case types that they send us. This next slide just provides a picture of the main hallway at our main office in Hunt Valley, Maryland. And then the next slide, a few internal photos of the hearing rooms that are available at the Hunt Valley location. On the lower left there, that is our ceremonial courtroom, hearing room, and that fits up to 70 individuals. We might use that for a large consumer protection division case that involves lots of claimants. Other hearing rooms have been outfitted to conduct hybrid hearings. So some people would be present in person and you'd have a computer screen to allow remote individuals to testify or participate. That's been especially important since COVID, and we have combined some hearing rooms to make more efficient use of our space and to allow for more hybrid hearing rooms. Then another picture here is of the clerk's office. As I mentioned, we have 26 clerks, perform a very important role because we are still mostly a paper office. We have a chief clerk and 3 deputy chief clerks. We also have satellite offices, small offices in Salisbury and Rockville. On this slide on the right, you can see the background that we use for virtual hearings. And I have to thank our IT department, Tariq Ibrahim, who made sure that we have a suitable looking background to make it a professional looking hearing. And when we do conduct hearings by WebEx, individuals are able to access those hearings without a computer. It was very important for us. They're able to access by telephone. So the hearing notice contains not only instructions on how to log in on the internet and give you the meeting room number, but it gives you a telephone number if you can't. We found that WebEx is an excellent solution for our agency, and people really appreciate the convenience. For example, attorneys who frequently represent individuals in motor vehicle cases appreciate that they don't have to leave their office and spend additional travel time going back and forth to Hunt Valley or an MVA location. All those cases are convenient to the individuals. Now, if a person receives a hearing notice for remote hearing and they don't want a remote hearing, they want an in-person hearing, we do that. In fact, every hearing notice that goes out advises the individual who receives it that they can request an in-person hearing. And our procedural rules specifically provide that you can show good cause for an in-person hearing if you're not able to remotely access the hearing or you don't have a suitable device for internet or remote conferencing. All you have to do is show us that that's the case, and you can have an in-person hearing. That's for all case types. We've also found that the remote hearings have led to a significant reduction in FTAs, failures to appear. This is especially pronounced for motor vehicle cases, Medicaid cases, and public assistance cases. It's much more convenient, we found, for the individuals who participate. This next slide provides some examples of the wide variety of cases that we handle. In terms of case volume, we saw that we're handling about 34,000 cases a year. The three busiest agencies are Maryland Department of Health, approximately 10,000, MVA, approximately 10,000 a year, and DHS, close to 4,000 a year. The other agencies comprise the other volume that comes up to 34,000. I did want to highlight some of the more recent, newer case types that are coming to OAH. And as you may be familiar, we hear handgun cases. We hear both handgun qualification license cases, as well as wear and carry permit cases. The legal landscape, as I'm sure you're also aware, is shifting in this regard. About a year and a half ago, the Supreme Court handed down the Bruin decision that involved a New York statute, wear and carry permits, and it contained the good and substantial reason language that was also at the time contained in Maryland statute. Supreme Court struck down that New York statute, and following that, we did see an uptick in not only the number of wear and carry permit applications submitted to the Maryland State Police, but also the number of appeals that reached our office. Also, as you can see on the lower right of this slide, we are closely monitoring the Maryland shall issue case, which is scheduled for an en-banc hearing before the Fourth Circuit.
Just as a parenthetical, and the gentleman who helped lead that effort is sitting behind you there. I'm not to tell that he's a great friend of mine, actually. So he's we don't agree on some of the policy, but he's a very, very talented attorney and a great Marylander, even though we don't agree on everything. But
And thank you for being here today. Also, another new case type, Walter Lomax Act. This provides compensation for those erroneously incarcerated. This was enacted in 2021 and became effective in July of that same year. Administrative law judges have authority to determine eligibility for compensation. The statute also contains the standard for determining the amount of that compensation. It is based on the duration of the wrongful incarceration. And our administrative law judges also have the authority to award benefits, including housing, vocational training, health and dental care, tuition and enrollment at institutions of higher education, and a state ID. We have handled several dozen Walter Lomax Act case. You may have seen these mentioned because typically they are mentioned in the press. That slide provides some statistics on the number of cases. We also sometimes hear cannabis cases. This has always been an area of discretionary jurisdiction. In other words, the old medical cannabis commission and now the cannabis administration has discretion on whether to send these cases to us. And this slide provides some data on the number of cases that we received in the past 7 years. Another area, and Senator Smith mentioned this one, MPAA, the Maryland Police Accountability Act. This is in some ways the successor to LEBOR, the Law Enforcement Officers' Bill of Rights. However, under the Maryland Police Accountability Act, our administrative law judges can serve as the chair of a 3-person trial board. So there's a police accountability board that sets up an administrative charging committee. The charge that is recommended by the administrative charging committee is entitled to a trial board. Our administrative law judges preside over those trial boards. And we have started to receive cases under this act. We are still working out agreements between various law enforcement agencies. And of course, there are many law enforcement agencies in the state, approximately 155. So we haven't gotten a case from all of the LEAs throughout the state, but we have conducted several of these and issued decisions. These involve both a bench followed by a written decision within 45 days. Just a few notes on representation at OAH hearings. Many people represent themselves. They're self-represented, often at, for example, MVA hearings. However, individuals can have private attorneys represent them. The departments often have assistant attorneys general. In personnel cases, we often see union representatives. And then in the case of incarcerated individuals, another incarcerated individual can represent that person. As I mentioned earlier, when COVID hit in 2020, we quickly pivoted, thanks to our IT group, to allow for remote hearings. And we initially started using Google Meet, but we found that WebEx is a better fit. It allows our administrative law judges to put participants in the lobby if they want to have off-record discussions or have settlement discussions. It also, WebEx allows for a static hearing room number, meaning we can send a notice weeks in advance that will not change. The meeting room number will not change, and everybody can rely on that as the correct place to go when their hearing comes. One of our core values is access to justice, and we want to make sure that everyone has the right to a fair hearing that they deserve. So we arrange for accommodations for those who are visually impaired, hearing impaired, non-English speakers, or any other accommodation that's needed. And in fact, with every hearing notice that goes out of our office, we include a request for accommodations form. So whenever we receive that form, we make sure that the necessary accommodations are provided. Also, last year, we partnered with the Maryland Department of Disabilities. They came on site at Hunt Valley to show us some of the assistive technology that can be provided to individuals who need accommodations. In terms of modernizing our office, a few points to make here. First, in the past year, we received funding for the first phase of our e-filing system. It won't be the MDEC system. It will be Caseload, which is the current case management system we use, and it involves expanding on the Caseload capabilities. So we have funding, as I said, for the first phase of the system. Also, in conjunction with the directives of the General Assembly and this administration, 2 weeks ago, we hired a Deputy Director of Information Technology specifically to address cybersecurity concerns. And so we're looking forward to making improvements in that area. Also, with respect to accessibility of past decisions by our judges, we recently upgraded our online portal for decisions to make it much easier to search for past decisions. And finally, this slide shows the 11 newest ALJs who were appointed within the past year and a half. This picture is from an investiture ceremony that took place in Hunt Valley on October 30th, 2023, and there are the 11 newest administrative law judges. So with that, I will open it to questions, and I thank you for your time.
I really appreciate, this is really great. And I thought it was important for us to understand, so much of the workload that you handle and help government work. And provide that access to justice, but so much of what we do overlaps with what you do. And it's kind of cool to see it on the other side after we pass a piece of legislation. And I was kind of geeking out looking at the Walter Lomax Act. I mean, we know there's a big piece of legislation. It was a bipartisan piece of legislation, and now you all are rendering decisions. It's kind of hearing the elements. And I remember us going line by line and writing those things down, and here it is in action. So that's pretty cool to see. Senator Sidor had a question, then we'll go to Senator West and then Senator Fulton.
Thank you very much. Good afternoon, everyone. As you all were presenting, I was on your website and was just curious, and just for educational purposes. So there's 30 state agencies that you all have hearings for. I'm assuming, you can correct me if I'm wrong, those 30 state agencies, was that codified in laws to those specific agencies rather than whomever else you might conduct hearings for?
I'm sorry, I didn't hear the entire question.
So there are 30 state agencies that are listed on the website, and there's a little matrix that was put together with a bunch of acronyms.
Yes.
The state agencies that you conduct these hearings for, is that legislatively mandated that you do it for those, or?
In many cases, it's either legislatively mandated or it's in their regulations. And we keep the delegation letters on file so that we have a clear record of what case types each agency wants us to handle.
And that was going to be my next question. Is that determined between you and the state agency, and then there's some sort of MOU that's put together?
Yes, it is. And a delegation letter or an MOU, we make sure that each case type is properly coded. And so if someone wants, for example, data about a specific case type, we've coded that internally.
Wow. And maybe I'm just not looking, but on this website, do you all have hearings that are going to be coming up? So if someone wanted to find out or to listen in on a specific hearing,
Absolutely. Many hearings are open to the public, and we can certainly provide you with either, if you'd like to sit in on a WebEx hearing, we could arrange that, or if you'd like to come to either Hunt Valley or Rockville and observe there, we can arrange that. Not just for members of the committee, but for the public as to hearings that are open to the public.
Thank you all very much. I appreciate it.
Thank you.
Thank you, Mr. Chair. A couple of questions. First of all, I love the fact that you're in Hunt Valley. It's in my legislative district. It's great to have everybody out there. I took a tour of your facilities a couple of years ago with the prior chief judge, whose name, Judge Pack, remind me.
Tom Dewberry.
Of course, Tom Dewberry, exactly. Who was a wonderful man, and it was a lovely tour. And I was very impressed. A couple of questions quickly. First of all, who appoints you? How do you get appointed?
A chief administrative law judge is appointed by governor for a term of 6 years.
Okay, and then you can be reappointed for additional terms?
Yeah, and
Okay.
I appoint the administrative law judges, including director and deputy director of operations and so forth.
Great. In the area hearings, do you apply the rules of evidence?
Administrative law involves, I guess, is a little bit more flexible when we apply rules of evidence, but in terms of hearsay, for example, it comes in when it's perceived by the ALJ to be reliable and relevant. Whereas that may not be the case with the district court.
And is examination of witnesses permitted?
Yes.
Yes.
In fact, it's required under the any witness who testifies is subject to cross-examination.
Okay, and then finally, what happens if someone is dissatisfied with the result of your decision? Where does the appeal go?
Typically to circuit court, in some cases to federal district court.
Great, thank you very much.
Or in cases where we issue a proposed decision, we put at the end a right to file exceptions with the agency. So it's either right to file exceptions, appeal to circuit court, or appeal to federal district court.
Thanks so much for your answers.
Thank you.
Thank you, Mr. Chair. Hey, welcome.
Thank you.
So I just have a question specifically. You put up the one thing about the Maryland Police Accountability Act and the MPAA, and I know you guys sit as the presiding law judge. And you have two others that make up the panel for these hearings. It's been brought to my attention that on some of these hearings, that while they get to that point because there has been no resolution on punishment because it's appealed, and it goes to these trial boards and then it gets to the hearing boards, that you guys are you guys doing in the presence of both parties a resolution, a mediation almost, if you will, and allowing it to not go to the full trial of things?
We convene the trial board. And
Correct.
so our ALJ is the
Is
chairman
on the
of
trial board, correct.
And we're there actually to hear evidence and make the decision in the case. If the parties wish to have a discussion before that hearing process convenes, they can, and they can present stipulations to the board.
But I've heard that the ALJ is making a decision that's basically creating an opportunity for the two sides to do their own almost negotiation for punishment.
And I'm not familiar.
Instead of having the complete trial board go through the motions, it's my understanding that's been allowed in a couple places, and I don't believe that was the design.
I would agree with you, Senator Folden. I'm not aware of that. I'm the Deputy Director of Operations.
I know
So
two instances.
I was going to ask you, I would be very interested to know about that because
Yeah.
part of our responsibility, not only in terms of training, but also for evaluation purposes, we listen to we listen to hearings.
Yes.
And so this Police Accountability Act process, as you know, and everyone here knows, it's evolving.
Sure.
But I agree that was not what the intention was. However, to Judge Leidig's point, there are several instances for the cases that we've had in which the parties have appeared before the trial board chair, that's the administrative law judge, the civilian member who's a member of the board, and the officer of equal rank present stipulations that they've reached some sort of agreement as to the charges.
Yeah.
However, they still want to argue about the disciplinary, the matrix piece. They want to argue about that piece. And so that's how it's what we've heard on that back end of sort of quality control and trying to have a better understanding about how the
Look,
process
I think
works.
you guys are being a great partner in this and being kind of thrust into this. I'm not being critical of that. I'm just saying that I believe that the way that this has been presented and the intent behind how it was to be designed, there's instances that I'm aware of where it is not completing that process. It's literally saying, okay, well, really, we don't need you guys, like, we're gonna work out something outside the framework of the matrix as a disciplinary matter, as a disposition, and we'll sign off on it.
Would you be willing to tell
I
me
will.
about that?
I will.
I will look forward to that conversation.
Thank you.
Thank you very
Yes, ma'am.
much.
Thank you.
Thank you.
Thank you.
Or Senator Carter and then Senator James. I wonder, in those instances, doesn't it still go to the trial board? Those are stipulations that are reached, and it's still.
It sounds like it's happening, at least if I'm understanding what you're saying, it's happening right, but at the trial board, before the trial board. So there have been instances in cases that we've received, there are cases that have been that the law enforcement agency has asked, has requested an administrative law judge. We've assigned one, and then they'll email us later or let us know, in essence, the officer is withdrawing that request because it was settled beforehand. So that's different. I think what you're saying is that they're at the trial board, at the location, and that there is some sort of mediation, settlement, something of the such happening at that point. That's something we will definitely look into. Thank you so much for raising that. It sounds like what Senator Folden is saying, that that's what he's heard, but I definitely want to look into it and would love to listen to the recordings on those. Thank you.
Thank you so much, Mr. Chair. My question is not anywhere close to that level of intensity. It's good to see you, Madam Saida Hampton L. And also Chief Judge Pack, we go back, right? You've been close to this committee for many years, but a different way. My question, so, you know, I think most people who don't have a lot of these issues just know of the Office for Motor Vehicle Appeals, which is most of my experience in practice. but I would be curious to know if it's possible. So you handle so many different subject matter, and I'd like to know if you keep any stats or data on the decisions in terms of like who prevails, the agency versus the challenger. I did some years ago have a contested case regarding a school closure, and I wanted to look up opinions to find out like what had ever been successful, but I had to go through like all of these opinions. There was no place to find out like, you know, the ratio of wins losses, and that might be a heavy ask, but do you keep any data like that in terms of the numbers or percentage of prevailing parties with agencies and the like?
We don't look at percentages, but we do keep a record of dispositions. And we also send out surveys to ask about were you satisfied with the process? And routinely we have very high marks on those surveys. So we consider that the best metric in terms of are we doing our job? Yes, the customers who come to us, the people who participate in the hearings, are satisfied with the process. Our caseload system does track dispositions. We wouldn't release individual case information, but we have aggregate statistics on that.
I would be interested in observing, of course, easier to do it virtually, but you know, a contested hearing on some issue of interest, especially the newer issues like the cannabis licensing or even the police cases. So I don't know how you could reach us for that, but if you have any that are actually going to go to an actual full hearing, some of us would probably be very interested in seeing that. Thank you.
Yes, we can arrange that.
Senator Smith, it is fine. And Senator Carter, it's a pleasure to see you as well. And yes, if you all we would love to have you, whether it's remote or in person. All the hearings aren't open to the public. So for example, personnel, we hear state personnel matters, grievances, disciplinary matters, those are not open to the public, or public assistance matters, medical assistance matters are not open, but motor vehicle administration, Police Accountability Act, those are. And so if we can work around, I guess in the interim, maybe an opportunity for you all to have an opportunity to observe some of the hearings. We would love that.
Thank you, Mr. Chairman. I just have to applaud you all. What a great presentation, great slides, great information. It was very easy to follow along, even if you weren't I am a lawyer, but even if you weren't a lawyer or not familiar. So I just want to compliment you on what an excellent hearing this is. So my minor questions are just a little follow-up, just to clarify a few things. So following up with my colleague, Senator Carter from the Baltimore City. So probably because they're not binding, I can't look up administrative law opinions, to see what's if I wanted to sort of figure out what at the administrative level is going on, which might help me as a lawyer, even if I'm going into district or circuit court, if I'm handling an appeal from an administrative law opinion. So that's not available. Or
many of our opinions are available on an online portal, and
Okay.
we just updated the search mechanism, so it's actually easier to find them.
So I could do a little bit like
Yeah.
I do with other cases, put in some search words and
Yes,
hopefully
yeah.
get some subject matter.
Yeah, you could do a search word. Also, we put it in the new design portal for easier access. So you could specify the agency and type of cases, then you could get all the cases in that particular field that you are interested in.
That's great. That's great.
And all you have to do is push button.
Perfect.
And if you're a paper person,
I
our
love
library
paper.
does maintain the paper decisions, and our library is open to the public in Hunt Valley.
Very good. On virtual hearings, again, I don't want to delay the hearing, just a little bit of information. We don't have cameras in, circuit courts and district courts. I actually agree with that policy. I understand both sides. But you all are open, a lot of your hearings, to the public. But if there was a
an issue of privacy or something sensitive outside of the cases you mentioned, how do you handle that?
We, that request would come, a request to watch a hearing that has confidential information involved. It would come through operations. We would alert the administrative law judge, and the administrative law judge presiding has the authority to control the proceeding and make sure that personal, confidential, personally identifiable information is all protected. So either individuals could be removed from the room, or if, for example, they were pressed, they would be instructed not to report on any personal information.
I guess what I was thinking about, if you don't mind, just to clarify, I'm thinking about, and maybe you don't see these kind of cases. It's such a vast jurisdiction. I don't want to come up with an example because I might not do an adequate job, but I'm thinking of somebody or a case in which there's a reluctance to testify. There's some concern. It's deeply emotional, where knowing that the public could be watching you is that a basis for asking for some limited access to that?
Yes, and
Okay.
yes.
Aside from the confidential, I mean, this is an intense hearing, a lot of emotion, maybe some vulnerable people involved. This will be hard for them, even
Right.
That level. Can you help protect that?
Absolutely. In
Okay.
addition to the rule on witnesses, the administrative law judge can exclude individuals where it's appropriate.
And if you don't mind, just a little bit more, rules of evidence, lawyers have a couple of Bibles back there and then a lot of great books on the subject as well. You all, do you have it written down how you are slightly different from rules of evidence? You indicated that, for example, hearsay, if the judge in his own inimitable discretion believes it's reliable and relevant, you would be a little different than, and there's a lot of strictness around it.
Yeah.
So is that written down for a practitioner to see? Number
Yes.
one, good. Second, I'm sure I could appeal if I thought it wasn't reliable or credible and it shouldn't have been let in. But are your rules written down?
Yes, so that is we have our own rules of procedure, and that's
Good.
Code of Maryland Regulation 28.02.01. And we
You're
have
an encyclopedia. All
the
right.
27 rules, and yes, the specific provision about hearsay can be found in the evidence regulation. And it provides that, and it's relaxed, but as Chief Judge Pak pointed out, the hearsay still has to be reliable, competent, and material. So
No.
it does still have to reach.
Yeah,
through it, but
don't think,
yep,
none of my
that's written
questions are
down.
challenging, more just trying to
No,
think.
it's written in our rules. It's also in the Administrative Procedure Act around hearsay.
And then just one last question or little group of questions. I am so impressed with all of the training you do, right? That really gives me a lot of comfort. I wanted to ask you if, just an easy yes or no, are all the ALR judges mediators, or do they can choose, and then of course they go through the 40 and they have to have the annual.
Mediation training is part of their requirements,
Okay.
and it follows Maryland Rule 1704.
Okay, and then how do I want to? You indicated, sir, that the governor selects the chief judges, if you don't mind me. That might be the right title. And you then approve all the other administrative law judges. Is there a criteria that you use, or, is there something, I know you have so many years of experience.
Yeah.
What is the criteria
Under
generally?
the statute, under the rule, you gotta.
Come up to the.
No, I'm trying to get, I
Yeah.
saw that there's a lot of geographic diversity. I'm sure there's
Yeah,
a lot of.
under the current rule, only requirement is you gotta be a minimum 5 years
I got
as an
that.
attorney in Maryland. But most of the individuals we select has on average about 15 years of litigation experience from all different parts of the state. What I try to do is get the best and brightest from all different parts of the state, as well as gender and the
Every kind of diversity. I can
every
pick
kind
up.
of diversity you can think of.
Yeah.
Because the geographic diversity is, I felt, just as important, so that all the states can be represented. And the fact that we are doing a lot more virtual hearings allow us to select people from areas who would not normally apply in the past, because now about 70% of their work can be done at home.
Right. I don't want to make this too long, and you can get back to me in
Yeah.
writing. I'm just curious, there's a very elaborate process, rightfully
Yeah.
so, for district and circuit court and beyond.
Oh,
A lot of
yeah.
committees meet at the local level. Interviews are conducted at the
Yeah.
local level,
Yeah.
resumes, references.
Yeah.
That's sort of what I was
Yeah,
asking.
yeah.
and not-
Oh, yeah,
sorry.
we have the process. We
Yeah.
have the, of course, application process, which must follow the Maryland law. And then, once they apply, for example, in the last election, we had over 80 some applicants who apply who are highly qualified. They go through the initial interview process, which includes writing after the end of the interview by the 5-member initial selection process. And after the interview, they are given 30 minutes to write a decision on an issue based on given facts.
Just
And you go through that process, and that initial selection process selects about 20 top qualified individuals, and they are subject to second interview by myself and the Director of Operations and Quality Assurance. And then I weight the view of the initial selection committee together with the feedbacks from the directors of quality assurance and the operations and my view, and I combine them and try to select the best qualified person possible. And that's how we've been doing it for last 3 years. And fortunately, we've been selecting probably the best and brightest from Maryland because of our reputation as a place where you want to work, and that attracts a lot of outstanding attorneys to our office, and we've been very fortunate.
Thank you. And Rob, let's not make the hearing any longer. If someone could just send me that in writing, would be great. And thank you very much. Thank you.
Now, I want to know who's on the committee and all that stuff, on the initial selection crop and all that good stuff. So, I mean, things like that. We'll make sure just like in the other hearings, we'll transcribe it. We'll send out an information request and we'll just redistribute it to the rest of the committee. But do you want to chime in, or?
Oh, you asked about who's on the committee. So the initial hiring committee consists of the Deputy Director of Operations by title. So whether it was me or someone else, the Deputy Director of Quality Assurance are the two mainstays. Then you have 2 administrative law judges, one experienced, one fairly new, and then a non-lawyer, a non-ALJ. So the last panel was the Deputy Chief Clerk, who handles motor vehicle administration, et cetera. And so she participated in that initial review of the 80 applications. It's an application packet of a state application, resume, certificate showing that the attorney's in good standing, references, writing samples, all those things are required. We review all of those things, schedule, narrow down from 80 to, let's say, 70 people, 60 people, maybe, give or take, that we'll interview, bring them in for an interview, everything that the chief said. Then we make recommendations to the chief. Those individuals then will have an interview as the chief said, and then he makes a selection from there. And so we've hired, I think they've hired some good people, if I would say so myself.
Yeah, in fact, we lost some of those people to the circuit
Sure.
court and the district courts in last 3 years. We lost 4.
I know they're poaching. Chief Judge Morrissey keeps telling me how well trained they are.
We just lost
Um,
one to the circuit court in Baltimore County.
Oh, wow.
Patricia DeMayo was
There you go.
recently appointed by Governor Moore.
Are we at, all right, Senator Sidnorth and Senator Carter.
Just out of curiosity, and I know this is a federal decision, but does the whole Chevron case, does that affect you all in any way in what work you all do?
Yeah.
So we are keeping an eye on
Okay.
what is going on with Chevron. For those of you who may not be familiar with it, although probably are, it speaks around the deference that is to be given to administrative agencies, particularly with respect to their expertise. And that is something that is part of the Administrative Procedure Act. That when we are hearing something that has been delegated to us, we are to follow the agency's settled existing policies and also to take into account the agency's expertise in that area when evaluating the evidence, whether that's the witnesses or the documents. And there's case law around that in Maryland as well. So it will be interesting to see what the ripple effect is from that decision when it comes down.
I'm curious myself.
That was just argued, right?
Yes.
Yes.
They just argued that.
Yes,
Yeah,
just
just-
last week,
Yeah,
I
last
believe.
Just last week?
Yes.
Yeah. Chevron deference.
Chevron.
All right. Yeah, Senator Carter.
Thanks, Mr. Chair. I was looking online just now because I was curious about the salary and it looks like there's a huge range from low to high. How is that determined when someone becomes an administrative law judge? Is it years of experience as an attorney or what's the criteria?
That all the new judges get this, starts at the same salary. And I think most of the judges are, even those who've been at the office for a little while, most of them are at the same salary level. But the Maryland ALJs receives much less than our counterparts in Washington, D.C. And Minnesota, Florida, but a little bit
How do you
higher than.
compare in terms of numbers and the numbers of?
Numbers is significant on, for example, Georgia and Florida ranges in about 150, and the DC ranges on around 180, and whereas our ALJs receive a little over 120, and because of that, even though we are able to attract a lot of outstanding people because of the diversity of work we do and kind of important work we do, but we lose many ALJs after training them to the federal and the other states because of the salary wise, we are not as competitive as some of those other states comparable to ours.
What are the restrictions on practice of law? There's 100% prohibited, all law,
Yes.
no, even if it's not
Yeah.
related, is,
Yeah, 100% prohibited once you join the.
so you can't be to hear MVA cases and do trust in the states outside, no?
Yeah,
On
we
the
don't
weekends.
we don't want to create any appearance of impropriety or conflict of interest.
Okay, thanks.
Happy to have.
She's getting paid so much in this General Assembly. Are any other questions? Questions with the committee? All right, thank you all very much. This has been really, really fantastic. Thank you all for the public service that you all do, and thank you for enlightening our committee. This is great.
Thank you
you.
for having
Thank you
us.
for having us.
Thank you.
Have a great day.
Excellent. All right, so we're gonna take a don't go far, 5-minute break, and then we're gonna start up hearings so we can get this show on the road. So 5 minutes, and then so she can reset the system, and then we'll start hearings promptly.